All right, Mr. Schmidt, are you anticipating contested hearings today? And you just had Mr. Larsey.
Oh, sorry. We had Mary Dawson. We had Larsey, that's in miscommunications on Larsey. They filed their response, but ultimately we need testimony. The state's ready to proceed. So,
That's right. State filed an answer to the motion to suppress.
I reviewed it.
And so we're just going to urge the motion today. We do not have witnesses ready to proceed on the contested hearing.
So just going to be asking for a reset, or do you want me to rule on the motion, or do you agree to it? Or?
I would like testimony, Judge, and ultimately, believe it or not, I think that they filed their response last week. I would wait to review that today. And it was my understanding that you guys were. So I'm like, okay, so that side moved on.
Yes, you accepted it in the e-filing system and it sent me a notification. I was under the impression that it had been signed. And this tape name informed me that was not the case, but it sent me a notification this morning that appeared that it had been accepted, which I understand that's not the same file, but typically in this court, that means the same thing. So
It was a big misunderstanding.
it was a very big misunderstanding.
Ultimately, though, Judge, I think that on the merits of the motion, I would ask for a hearing and testimony. I understand the state's not ready. Obviously, no, I'm not ready because. So, I'd ask for a reason on that one. Jocelyn, come to an agreement to resolve the writ issues. So that should send it. Both is not today.
All right, so what we'll do is in just a minute, we'll bring Larsey up.
Okay.
And I'll reset. I'll grant the motion, and then we'll reset for the next evidentiary hearing.
The motion.
Or no, it was a written. What I reviewed was a written
We filed a
response.
response in a state.
It was an
order.
objection, wasn't it? Was it
It
an
was,
objection? to
no,
it?
it was an order denying the motion to suppress.
Just based on it being vague or?
Yes. Not
And
saying.
that's the case, Judge, that's fine. I would file.
No,
But I think it
no.
was, I mean, in other words, if I respond to, I'm fairly sure it was very specific.
I guess the way I read it was an objection to the motion on lack of specificity, unable to prepare, was going to grant that, reset it for another contested day so that we can bring in the officers, but I don't want you to have to refile it.
Okay, whatever.
And I'm assuming that you two will talk about it to get down to those issues, or are you going to file an amended one?
Both.
Because the way I read the motion was it was lack of probable cause for the stop. That's the only specific thing I could find.
Yeah, I think though,
Allegations
if I
of
recall correctly, when you're looking at those cookbook motions, you expect to see certain things at certain places. My allegations, if I recall correctly, and they're tied into the other issues because it's a little bit more specific than normal. So I understand if she didn't see them, then I'll either refile it. But either way, we said it and resolve that.
And Judge, he and I have had conversations about it. I think after our conversations, I'm pretty clear on where his issue lies, so we can get our officer here to address that.
Okay, so then I will not rule on, I'll take it under advisement. And then if you're telling me that you understand, you're on notice of what it is, then I'll just reset for the October 28th. That's the next contested. Okay. Yeah, sure. Just let me know when you're ready. Ms. Thompson? Ms. Thompson? Are you Ms. Thompson? This means come forth. Come hither. Right there. There you go. All right, this is cause number CR 15506, CR 21193, State of Texas versus Audrey Jean Thompson. Ms. Thompson, the court has appointed the Honorable Bill Stevens to represent you. Have you met with Mr. Stevens? You have not. And just so that you're clear of kind of what's occurred here, Mr. Knoll was representing you. No need to go back into all of that. Mr. Knoll was removed. We appointed Ms. Beasley to represent you. Ms. Beasley indicated to the court that upon receiving your case and reviewing it, that she has a conflict in that she represents someone else that may have interests that would be in conflict with yours. So she has to legally be removed. So we removed her. Then we appointed Ms. I believe Casey Chester. And after reviewing your case, she also has a conflict with another co-defendant potentially in your case. So we've just been going down the wheel till we're trying to find an attorney that doesn't have a conflict to represent you. And we've landed on Mr. Stevens. And Mr. Stevens has had an issue at home today that prevents him from being here. So rather than just leave you in the jail, I wanted to bring you over and tell you what was going on. So I don't believe I have any other attorneys on the wheel that are here today that could take up your case. And even if I appointed someone else, they're not going to be ready because they'd have to review the discovery in your case. So the best that I can do for you is I'm going to have to reset you, but I'm going to do it for a shorter time. The quickest I can get you in here is October 14th. So it's about 2 weeks. Okay. So I'm going to do that. I'm going to reset and then Mr. Stevens should be by to see you very soon. Okay. Any questions? Not at this time. Well, you have a bond on your pretrial case, your burglary of a building, but not on your motion to revoke. I understand. I signed the warrant to put you there. Ms. Chitty, you'll come forward. This is cause number CR 16196, State versus Tana Marie Chitty. Ms. Chitty is set on a motion to revoke today. Ms. Chitty, your attorney is Mr. Mitch Adams, and he is in trial in Smith County in Tyler, so he can't be here today. He started trial this week, so I'm gonna have to reset you as well. And I'll set you as soon as I can get you in, which would be October 14th. Have you been in contact with Mr. Adams at all? Has he sent you a letter or visited you or anything like that? Okay. Well, I'll touch base with him and find out when he expects to come see you, and we'll bring you back here on 10/14. Okay. We're gonna sign this notice of setting right here and then give you a copy. Mr. Knoll, are you ready on Ms. Parker? Is that going to be a contested hearing?
There's going to be some testimony. I think, on 3 cases that I have brought.
Are we going to have a contested hearing?
Yeah.
We are. How long do we anticipate that'll take, Mr. Knoll?
Probably 30 minutes.
Okay. All right, Ms. Parker, go have a seat. I've got to do a hearing at 2 o'clock and then we'll call you right up after that. Okay. You ready? Mr. Larsey, let her sit down. Let her sit down. And then once she sits, then come on up. This is cause number CR 2178, CR 2179, State versus Daniel Scott Larsey. And we were set today for an evidentiary hearing in CR 2178. It's my understanding that the state has filed a response to the motion to suppress, objecting to lack of specificity on bringing the state on notice of what's being alleged to have been the illegal issue subject to suppression. Is it my understanding that the parties have since spoken about that and both are in agreement that we're not going to proceed forward today?
Correct.
Okay, so the court will reset this for an evidentiary hearing, which is still requested, correct, Mr. Schmidt? We'll reset this for 10/28 at 1:30. Has he already made bond?
Because we filed.
We didn't bring it. Okay, this is in written number WR 2150. Garrett Lee Jocelyn. Go ahead, Mr. Schmidt.
Judge, you and Ms. Hazard have been working on this issue quite very good. What we agreed to is the state agreed to post a PR law on all charges except for the aggravated assault of the case in which the state has agreed to reduction of $20,000 surety. And that would resolve the issues. For purposes of the people, I believe that there is a proposal has the ability to enter information and or like prepare a cleaner or one that's already filled out, whatever.
No, that's okay. If there's one in there, I'll go. So it's PR on everything except the ag assault deadly weapon. And it's agreed at 25,000 cash or surety. Okay,
So that just for the court's record, that should take a deadly conduct, aggravated sexual assault, and an aggravated kidnapping. Those are 3 agreed PR on.
so you said ag sexual assault,
Please.
ag kidnapping, and this is your motion. Right?
Yeah, there should be 4 charges.
Can I tell you if y'all want to fill that out
Sure.
and sign it, then that'd be fine. I see a yellow copy of this. Check your connection again, make sure you're on. Do you think either of the ADAs have phones like that? I tell it to forget that network. Tell it to forget it.
Sí, sí, lo escucho bien.
Test. Okay, you can hear him now? Yes, I think he's unmuted now, isn't he? Can he hear you? You can't hear. Ask him to say, yeah, we're gonna move a microphone because for some reason we're getting feedback. If you, let's try it though. Let's unmute him and see. It was creating a feedback loop for some reason into my computer. Did you hear me? Unmute his computer.
Sí, sí, lo escucho.
Is it gonna work? I don't know what the issue is. Okay. All right. You have my document. Leonard. All right, this is in cause number CR 23-4, State versus Remedios Mendez Gonzalez. This time I'm going to swear in our official interpreter. Mr. Perales, if you will raise your right hand, sir. Mr. Perales, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, you may put your hand down. As soon as I get the plea papers. Mr. Mendez, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Oh, here it is.
There is also for the protective order attached to that, which will be secretary after. you have that as well.
Okay. Ms. Heisel, will you give this to Mr. McCaslin and give it to the defendant? That'll be his copy of chapter 62.
You have a copy as well. We were just gonna attach this
You
to
want it in the
conditions
record?
of probation.
Okay.
The jail, but if we attach conditions of probation as well, that way we know what he got.
All right, before I begin with the defendant, Mr. McCaslin, have you had an opportunity to go over all the paperwork with your client?
I have, Your Honor.
And for the record, you are bilingual, correct?
Correct, Your Honor.
And did you explain these documents in the Spanish language for the benefit of your client?
I did, Your Honor, and it's also my belief that you understood my interpretation of the law.
And do you believe him to be competent today?
I do so, Your Honor.
All right, Mr. Mendez. Are you a United States citizen? You're not?
No.
Do you understand, Mr. Mendez, that if the court makes or accepts any kind of plea today, it could have an adverse effect on your status in this country? And have you spoken to your attorney, Mr. McCaslin, or any other attorney about the immigration consequences that could result from today's plea? And understanding what the risks are associated with your status in this country, do you wish to go forward with this plea today? And you do not read or write or speak English, is that correct? Now, in this paperwork, I see that you have placed your signature. Did you place your signature in this paperwork after having your attorney, Mr. McCaslin, explain to you the rights that you are afforded and the rights that you are waiving? And did he do it in the Spanish language to the degree you feel like you understand everything you have read and signed? And in this document, is this your true and correct signature that I see? And Mr. Mendez, have you ever been diagnosed with any type of mental condition?
No.
And are you pleased with your attorney, Mr. McCaslett? Do you feel like you've had enough time to talk with your attorney about the case and have all your questions answered?
Sí, correcto. Tuvimos suficiente tiempo.
Okay. You are charged by indictment with a second-degree felony offense of sexual or indecency with a child by sexual contact. A second-degree felony carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. And I see here that Mr. Mendez was actually indicted with first-degree felony offense of aggravated sexual assault of a child, but the plea agreement would be to a lesser included indecency with a child by sexual contact, a second degree.
That's correct.
Mr. Mendez, if the court approves this sentence recommendation and plea bargain today, do you understand that if you are placed on community supervision and you violate your community supervision and the court conducts a hearing and finds that you have violated your conditions, the court could convict you of that offense at a later date and sentence you to prison from anywhere from 2 years to 20 years.
Sí,
All right, understanding the range of punishment and the plea agreement, how do you plead to indecency with a child by sexual contact? And Mr. Mendez, are you pleading guilty because you are guilty of committing that offense? All right, Mr. Mendez, has anyone threatened, forced, or pressured you to plead guilty to this charge?
no.
All right, the court will accept the defendant's plea of guilt. Mr. McCaslett, any objection to State's Exhibit 1? All right, State's Exhibit 1 is admitted. The court takes judicial notice of the defendant's judicial confession. State, is there a victim impact statement related to this case?
There is not a victim impact statement. I have met with the victim. We discussed several different outcomes. Nancy believes that this important purchase.
And the victim's a child, is that correct?
That's correct.
I see that was the victim a child on or about February 14th, 2016? Is she still a child today?
Yes, Your Honor. I believe she was 12 at the time, and I believe she just.
And when
Yes, I believe she was 12 at the time of the alleged offense and is 14 now.
And in your meeting with the victim, you met also with a representative of the victim or a parent?
I met with her mother as well.
And the victim and the family are supportive of this?
Yes, Your Honor. the defendant is the stepfather of the victim. The mother of the victim also has children with the defendant. And we talked about that family dynamic. And we believe that this would be in their wishes.
And is there I have not gone through the evidence and I have not looked at the conditions of community supervision. It's my understanding that there's going to be a protective order, an agreed protective order in place. What's going to be the living arrangements? Will the defendant have any access to the victim?
Your Honor, no, the victim is not the biological child of the defendant, and as such, we don't believe that he has any legal right to her. We have had no contact as to victims specifically, but we did not include in the provision the condition that he not communicate with the family, because obviously he would need to communicate with the mother in respect to his own children. We are just asking that there be no contact with the victim, which is her wishes as well.
And so the victim's not residing in the same household as the defendant.
No.
Okay.
Your Honor, if I may, my understanding that
And you may need to come forward just so the interpreter, our microphones are not working. So I
my
apologize.
understanding that the victim's mother is in a relationship with someone else, and there's no chance that these two folks will.
I believe they're in the process of getting a divorce, but I don't believe that has been finalized, Your Honor.
All right, thank you. Anything further from the defense, Mr. McCaslett?
Time, Your Honor.
I'm going to just take a moment and review the evidence. All right, based on the court's review of the evidence, I find enough evidence to convict Mr. Mendez of this offense. The court will follow the recommendation of the state of Texas, which is also based on the request and wishes of the victim in this case. Court will follow the plea agreement. The court will defer a finding of guilt. Court will place Mr. Mendez on 10 years deferred community supervision, assess a $4,000 fine, order Mr. Mendez to pay $290 court costs, $70 reimbursement fees. Court will find that this offense does require sex offender registration under Chapter 62 of the Texas Code of Criminal Procedure. Court's going to have the record reflect that the defendant is being provided a copy of Chapter 62 as required by the Texas Code of Criminal Procedure. That's being provided to the defendant attached to the conditions of community supervision. And I believe a copy's also been provided to the defendant in person today. Counsel, will you approach? This is inconsistent with the judgment.
Yes, originally we had a, yes, Your Honor, this is a, there was a error at first where it was a third degree or second degree. A second degree, so, and it is deferred, so there's a 0. If you want to go on the record.
So what I'm gonna do is I'm gonna mark it out and then I'm gonna go and have, I want you all to initial that. Or you usually put it down here another. All right, so Mr. McCaslett, I want to ask that you present this to your client and get his signature indicating that under paragraph 4 of the written plea admonishments that the plea agreement is for 10 years deferred community supervision. The deferred adjudication. Have your client do that.
We are making a correction.
Mr. McCaslett, I don't think Mr. Perales is able to hear you. I don't see him translating. So if you want to, you can either talk in that or come up here because he'll be able to hear you.
Can you hear me, translator?
Try the other microphone.
Translator, can you hear me?
He says yes.
Sure. Procedural amended. We understand that you are getting 10 years deferred adjudication.
Just come up here and he'll, Mr.
Mr. Remedios Mendez, you understand you are receiving a sentence of 10 years deferred adjudication. And I explained to you that if you satisfactorily complete that term of probation, the court at the end would likely enter a finding of it being not a final conviction. I explained that to you, did I not? If he successfully completes his term of deferred adjudication, it will not result in a final conviction. Did I explain that to you, Mr. Mendez? I also explained to you that deferred adjudication is a double-edged sword. If you violate a condition of community supervision, the court could bring you back and sentence you to the full range of punishment. That is anywhere between 2 to 20 years. Was that explained to you by me? Now, on the paper that I have here that you signed, page 2 of 6, we incorrectly put in there a term of imprisonment of 5 years. That doesn't apply. It's actually only 10 years deferred adjudication. Will you initial the corrected copy of this? But I'm going to approach the defendant and have him initial, but he understands that this is a 10-year deferred adjudication, community supervision sentence.
Thanks, sir. Ms. Heisel. Has this been filed?
Because it was approved, I didn't know if we filed the application.
Yeah. Because I don't think I can grant it
Okay,
unless it's filed in jurisdiction.
well, that's true. And I put the calls number to talk about it's not.
Probably because it'll have to be a civil cause number. And that's cheated.
Let me just open it up and see if we can get it on.
And we don't need that on the record if it's.
If it's approved. Okay.
Your Honor, I'd like to inquire a couple of questions from the defendant. if I may.
Ms. Heisel. Mr. McCaslin is going to take him on the record. Go ahead, Mr. McCaslin.
Mr. Mendez, I explained to you, did I not, that just because you pled guilty today to this offense, and if the judge grants you community supervision, that doesn't mean that immigration cannot come and pick you up and have you deported. I explained that to you, did I not? And you understand that this court has no power to keep you in the country just because they placed you on probation. And as far as your immigration consequences, I explained to you that this type of conviction is classified by the Department of Immigration or as a aggravated felony and also a crime of violence. Therefore, it is unlikely that you will ever have a pathway to citizenship in this country, and or you will likely never be able to legally come into the United States. You do realize that, right? That's all I have.
Any questions from the state?
No, you're off.
All right, Mr. Mendez, the court is going to remand you to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I need you to step forward so I can have you fingerprinted. Do you have any other need for the interpreter, Mr. McCaslin?
I do not, Your Honor.
All right, I believe that's all, Mr. Frawless. Thank you so much for helping us today. You as well. And the state has filed motion to revoke community supervision, I believe, April 29th, 2021.
That's correct, Your Honor.
Mr. Knoll, does your client waive the formal reading of the state's motion?
If we haven't reviewed this, we would wait for the reading for her.
All right. And is your client pleading true or not true to the counts today?
Within, as the state's motion is true, I understand though, the probation would be where the count two, which is basically the money. All caught up this time, the others would have a witness. Possibly Ms. Carter.
So the pleas are, she's going to plead true to each one of the counts? Okay. All right, so, and there's no agreement with regards to a resolution of the motion?
That's correct.
All right, so Ms. Parker, you appeared before the court on August 13th, 2019. You pled guilty to the state jail felony offense of abandoning or endangering a child with criminal negligence. The court heard the evidence, found that there was enough evidence to convict you. However, the court did assess your punishment at 2 years confinement in the state jail division of TDC. And the court suspended that sentence pursuant to your plea agreement, placed you on community supervision for 5 years and ordered you to pay a fine. It was during that term of your community supervision that the state has filed a motion to revoke, and they have alleged in 3 separate counts ways that you have violated the terms of your community supervision. Have you had enough time to review this motion with your attorney, Mr. Kirknall?
Yes, sir.
And do you believe you've had enough time to discuss the case with him, and have all your legal questions answered?
Yes, sir.
All right, so I'm going to ask you at this time, how do you plead to counts 1? How do you plead to count 1? True or not true?
True.
And how do you plead to count 2?
True.
And how do you plead to count 3?
True.
All right, and Ms. Parker, has anyone threatened, forced, or pressured you to plead true to any of these counts today?
No, sir.
All right, the court will accept the defendant's pleas of true to each count as alleged. State, do you want to move forward with putting on evidence at this time?
Yes, Your Honor. State has one witness.
State has what?
One witness.
Go ahead and call your witness.
Your Honor, state will call Karen Bryant.
Ms. Bryant, just step over here. Go raise your right hand. Ms. Bryant, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat. You can move that chair around to be comfortable. Just try to sit as close to that microphone as you can. Make sure you speak up loudly and clearly so everyone can hear you. My court reporter to the left, very talented, but it's hard for her to type down what 2 people were saying at the same time. So as the attorneys are asking questions, let them finish. I'm asking the attorneys to extend that same courtesy to you as well, so that we're not talking over. Sometimes we get to the point of, you know what they're asking and you want to start giving the answer before the question's over, and it causes a big mess. Avoid doing that for me, okay?
Yes, sir.
Ms. Heisel, go ahead.
Thank you, Your Honor. Ms. Bryant, would you spell your name into the record?
Sure, yes, it's CAROLYNBRYANT
And how are you currently employed?
with the Van Zant Community Supervision and Corrections Department.
And we have here Ms. Ashley Parker. Is she one of the caseload assignments on your caseload?
Yes, ma'am.
And how long have you been supervising this department?
Since February of 20.
And prior to that, do you have knowledge of her being supervised by other members of your department?
Yes,
If I had a pretrial intervention contract with the date of January 2nd, 2018 on it, would that be consistent with your records on when Ms. Parker first began reporting to you guys outside of the standard pretrial release condition?
yes.
And do you know how long Ms. Parker was on that pretrial intervention contract?
I'm looking at my paper that I wrote the information down on. from until March 13th of 2019, when it was terminated
Okay, do you know if she was discharged successfully or unsuccessfully?
unsuccessfully.
And do you know the reasons stated for that?
I do not, I just have written down violation of conditions.
So who in your department supervises the pretrial intervention participants?
Our chief officer, Ms. Karen Burns.
And if Ms. Burns issued a memo with violations in it, to the best of your knowledge, would that be accurate?
Yes,
But you're not personally aware of what those would be.
correct,
And you said that was March 13th of 2019, is that correct?
correct.
And then did you, or did your department receive, make sure I have the date correct for you, on August 13th of 2019, did you receive a judgment, or your department receive a judgment putting Ms. Parker back on probation?
Correct.
And do you know what the terms of that were?
I know that she was placed on 5 years adjudicated probation.
Okay, so 2 years in state jail, probated for 5 years.
Correct.
And during that time, you said you began supervising her in 20, so did she have somebody else supervising her from 2019 to 2020?
Yes, Officer Jarvis Crawford.
Also with your department?
Correct.
And then you inherited her file in 2020, is that correct?
Yes.
Okay. And so you were here, Ms. Parker, pled true to all of the allegations, mainly being failing to report, failing to pay fees, and failing to do community supervision. Does that cover her violation?
Correct.
And do you have what months she did not report?
I do not have that in front of me, but I know that the last visit was October 1st of 20.
Okay, so you have not seen Ms. Parker prior to today since October of 2020.
Correct.
And in that time, has she made any attempt to call you, email you, any other forms of check-in?
Other than in November, her child was sick and she couldn't make it to her appointment, and she sent a letter showing that her child was sick, but other than that, there has been no contact.
So in November of 2020, she notified you of the reason why she couldn't make her appointment for that.
Correct.
But then there's been no follow-up communication from her whatsoever.
Correct.
Your Honor, I pass.
Mr. Knoll.
Thing that, Ms. Brown, it looks like that in looking at the state's motion, we actually entered the plea on this case and was placed on term of probation August 2019. I think you indicated you came on as the supervising officer February of 2020. Correct. So for about 6 months, you were supervised by another officer.
Correct.
I don't know when each county says it's going to hit, but I know almost every, well, I know every county in this state was affected one way or another, starting in March. That's the first thing.
True.
And in March of 2020, how did the reporting system, if it did change?
They did by mail, by telephone, and still in person.
So you actually did have some in-person visits?
Correct.
Were there ever emails by way of, and I guess maybe that's another form of mail, but also by email?
Correct.
Now, it looks like, again, referring to the allegations, 6 months of the non-reporting, it looks like during the period of COVID, would that be a fair statement?
Yes.
And then there are 3 months, which actually are the months alleged this year, January, February, March, be, I guess, we maybe say not. I think you said November. November, there was a letter indicating you had a child.
Yes,
The record reflects she has 4 children.
I'm unsure. I can look, but I don't know.
You haven't filed with that.
I can look on the computer.
Okay, if I were to represent to you that she has 4 children, would you have anything that indicates she didn't?
No,
And as far as employment, you recall where she was employed at the time of filing a promotion.
yes, sir, at the Quick Clean Car Wash.
Who moved that?
Were you aware that at some point in time she started working at a Sonic?
No, sir, I was not aware of that.
During the period that she was, I think, working at a car wash, you know how long that was?
No, sir, I did not.
And she has played through that too, which was obviously not paying certain costs timely, just like court costs, fines, and insurance fees. As of today, have those fines, court costs, and insurance fees been caught up, or have payments been made for them?
Yes, sir, they're current as of today.
Okay, so as of today, granted, she did not do it timely, but as of today, all those payments have been made.
Correct.
On the community, count 3 on the community service. Again, I'm gonna kind of break this down, pre-COVID and COVID. I did my calculations correct, looks like there's 180 hours total missing in 10 hours a month, so that'd be 18 months. And I think 50 hours, so those were 5 months of those are pre-COVID. And I think 130 months of this community service for during COVID, would that be a fairly close breakdown?
Yes, I would agree, it's close.
During COVID, where were individuals assigned, or how were they assigned to do community service?
There were still special projects that they were able to do where they could keep their distance from one another. For example, the Edgewood Heritage Park. It's a big area, so they were able to stay within the CDC guidelines. So we still offered community service during COVID.
Okay. When you say offered, how was each probationer notified that there was at least a park? I assume the park would have been either mowing or cleaning up or something that.
Yes,
And how are they notified of that?
I'm unsure of that.
So you would have no knowledge today if she was ever notified of that.
Correct.
I believe I have further questions this time.
Any further questions? Ms. Hazel?
Just a few, Your Honor.
Go ahead.
So Ms. Bryant, when COVID hit approximately March of 2020, you said that they were able to make their appearances by phone, mail, sometimes, is that correct?
Correct.
So would it be fair to say that it actually became easier to report to your probation officer once COVID hit?
Correct.
There are more options for facilitating that other than appearing in person?
Yes, correct.
Is it your testimony that Ms. Parker never tried to pursue any of those alternative means with the exception of November?
That's correct.
And approximately how many people do you have on your case?
About 90.
And were other members of your caseload able to complete their reporting requirement? Your Honor, I think that the general ability to carry out those requirements is relevant as to whether this defendant failed on her own volition to complete these requirements.
But without having access to the other 89 files, I would be able to cross-examine.
Overruled.
Just Jim.
I'm sorry, can you repeat the question?
Sure. Generally speaking, were members of your caseload able to report given the amended ways of reporting?
Yes, correct.
And if I am reading the state's motion to revoke correctly, the only month since being placed on completed probation that Ms. Parker completed any community service was February of 2020. Is that accurate?
That's correct.
So with the exception of that 1 month, every single month she failed to report any community service.
Correct.
No further questions, Your Honor.
Mr. Knoll,
No further questions.
thank you, Mr. Bryant. You can step down.
And Judge, we would ask that she be permanently excused.
Any objection, Mr. Knoll, to Ms. Bryant being excused? Okay, you're free to go.
Your Honor, stay with rest.
Mr. Knoll, do you want to offer any evidence on behalf of the defendant?
I think Your Honor, we can follow up with Junior.
Mr. Turner, you'll come forward, sir. Come up here, sir, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got, please have a seat. You can move that chair around. Comfortable, but try to be as close to that microphone as you can so that we can all hear you. You were in the courtroom when I gave Ms. Bryan instructions on not speaking over the attorneys, correct? And speaking up loudly and clearly? All right. Go ahead, Mr. Knoll.
Thank you, Judge. Mr. Turner, would you say the full name? You know, the individual seated to my right.
Yes, so that would be my wife, Ashley Parker.
Okay. How long have you been married?
Since March 31st, 2017. So about 4 years.
Let me ask you questions. First off, do the two of you have any children together?
I'm sorry.
Does she have any children?
Yes, 4 girls.
And you know approximately the ages of those 4 girls?
7, 11, 13, 14.
Where did the two of you reside?
And girls from Texas.
And do the children go to school in Wilson?
Yes, sir.
At the time Ashley was arrested on the state's motion to revoke the supervision, where was she working?
She was currently a Sonic intern.
You recall approximately how long she worked there?
I know more than 5 months. No.
Do you know what her position was at the Sonic intern?
Assistant general manager.
Are you employed there?
Yes, sir.
Where are you employed?
At Bison,
Where's that located?
in between Wilson and Terrell.
Now, if the numbers are correct, I believe Ashley's now been incarcerated approximately 62 days. During the 62 days, had the 4 children ages 7, 11, 13, 14 continued to live in your household.
Yes, sir.
And if you're also employed, has it been, I guess it was to say, kind of difficult working in tending to the needs of the 7, 11, 13, and 14 year old?
Yes, sir.
managed to do that so far?
I had help with my mother and, their other grandmother, which is her mother. I mean, I just do everything I can, to make sure everything's still go the way it's supposed to.
How about, I assume that during the marriage inspection, since Ashley was, and has been working, that the financial support from her job was something that was also needed in the family.
Yes, sir.
The and certainly she understands. The attorney's office does, but one of the things that she didn't do timely was to do what's called community service. I think from my 37 years of experience, there's a couple of things that really upset them. One is community service. The other one is not showing up. You're supposed to show up. Will she have, meaning actually, adequate transportation to get wherever she needs to get for community service?
At the time, no.
Okay,
Now it's still happening.
okay, well, I don't know what necessarily, and I think it should be raised at Will's point.
Yes, sir.
I don't know if necessarily be available at Will's point, but if necessary, will arrangements be made with that with you or another, or I think you said, or another,
Yes, sir.
to give her wherever she needs to get to catch up and make up and do what she needs to be doing if the court decides that they're on probation. So I promise you, if the judge does that, if she missed one month, but then you serve her off to be right back where we are.
Yes, sir.
So can you guarantee or the best of your ability to get her to where she needs to be community service?
Yes, sir, I can.
The other thing was reporting. I don't know that I can say pre-COVID or COVID or what. But reporting means doing whatever Mr. Bryant says to report. Whether that's as simple as mailing something, I guess email accounts, making phone calls, and showing up. They may require her to physically go to offices. It's about a block away. Is there gonna be a ride available to get there?
Yes, sir.
I would have that.
Ms. Heisel?
Your Honor, state has no questions for Mr. Turner.
All right, any objection to Mr. Turner being excused? All right, Mr. Turner, you may step down. You're free to go. You may.
Regardless, that's all we have.
All right, so that's,
Your Honor, the state who just asked the court to take judicial notice of the memo from the probation department to the United Court Judicial District Court that was present in funds.
any objection, Mr. Knoll?
Judge Guy, do that since I have not seen it or not. I just want
You may.
I don't have a problem with that. It looks like it's reporting.
All right, the court will take judicial notice of the memo from the Community Supervision Corrections Department regarding the discharge from the pretrial intervention program. All right, State, would you like argument?
Your Honor, this court placed Ms. Parker on pretrial diversion in conjunction with the DA's office back in 2018, giving her ample opportunity to regain custody of her children, work her services, do the things that she needed to do to make sure she was with her children. Your Honor, she approximately 6 months into it, decided that she just didn't need to show up anymore. The district attorney's office chose to give her another chance by adjudicating her, placing her back on probation. I was not here at the time, but I am confident, just because I know the way this court operates, that she was given explicit directions at that time that she was being given a second chance and she needed to take care of her business. At that time, she was assessed 2 years in the state jail division, probated for 5 years. Your Honor, again, even knowing what was hanging over her head, she decided that she didn't need to report, even though it was easier at that time to report than it previously had been. A simple phone call would have put her on record reporting. However, we don't have that for a year's worth of time. No attempts at paying her fees, no attempts at doing community service, and no attempts at even letting us know that she changed jobs or where she was at. Any information at all. She just decided probation wasn't for her, she didn't want to do it. So, Your Honor, the fact that, and I understand Mr. Noel is just doing his job, but the fact that Ms. Parker would come in here and have her attorney ask with a straight face for this court to put her back on probation is preposterous to us. She has already been given 2 strikes, and Your Honor, we would ask that you sentence her, or you would hope that has already been sentenced, which is 2 years in the state jail facility.
Thank you, Ms. Heisel. Mr. Knoll?
Just, one time I had a student say to me, they were probably accepting a plea deal that would send them to prison or decided who or not to. I'm not the only one voting. Meaning family does. It affects everything. I know that better than anybody else in this courtroom except some of the people back here. I have a son that's done about 10 years in 2 different states. It does. In this case, the state apparently wants you to sentence Ms. Parker to 2 years. And if I understood, and I don't have all the background on this case, that at some point in time, obviously she worked with CPS to gain custody of her children, which obviously she has. Didn't she? Apparently she never did CPS, I guess it was just through the DA's office. And she has, actually, I think it would be 8 months where when apparently there's no reporting, apparently she did send the letter during a period of time. On the option of working at a park, Ms. Bryant's testimony, she did not know whether or not she was ever given that option during COVID. Apparently, either through the efforts of her husband or her mother or both, all of the fees were current. If the numbers are correct, Ms. Parker's been approximately 62 days of incarceration at this point. She still has a husband who is here today, standing beside her. She has 4 children, 7, 11, 13, 14, that obviously need their mother for all kinds of reasons. Court has all kinds of options. One of the options that the court has, I guess, exercised simply by issuing the warrant is to lock you up and see how you like being locked up. I think being locked up, can't imagine that it's that likable, I guess, for lack of a better way to put it. One of the court's options is to actually impose a number of days in jail as opposed to just revoking the probation, conditions of probation. Personally, I think 62 under these circumstances is enough. The court thinks 90 days is enough. I believe this is the type of case, considering all factors, where the court should, quite honestly, leave her on probation if the court feels that some additional jail time is necessary to do that. But I think revoking the probation in this case really does not serve what we are here to do. I'm here to serve her needs. All of us are supposedly here to serve the needs of the community. The community, I think, is more interested in having a mother of 4 out working, taking care of her children, and learned, I hope, the necessity of doing everything timely that is listed in the terms and conditions of her probation.
Mr. Knoll, did your client tell you how she got on probation in the first place?
That, if I remember this case, it's a case involving, yes, I recall that, and I mean, I better stand back up. Did I go into great depth? No. Did I understand basically, and it's probably one of the reasons why I was pre-trial first, that there was an issue of a car wreck. Maybe some of the children, 2 children were actually in one seatbelt as opposed to a separate seatbelt, or maybe one car seat. I understand that. I didn't read the file. I don't usually read the entire file. The court has obviously access to that. I'm here on these issues, but I was aware that it involved an injury to.
Thank you, Mr. Knoll. Ms. Parker, you've had 2 bites at the apple. Pretrial diversion. You didn't successfully complete that. Case could have been dismissed, records could have been expunged. Second bite of the apple is your probation. Court's going to find that you have violated the terms and conditions of your community supervision. Court has already accepted your plea of true to counts 1, 2, and 3. Court finds counts 1, 2, and 3 to be true based on the evidence. Court is going to revoke your community supervision. Court's going to find that your payment of fees to make you current is mitigating in this case. That's a check in your favor. Court is going to sentence you based on the underlying case. I'm not sentencing you for your failure to report. I'm not sentencing for your failure to not pay court costs or your failure not to do your community service. Those are the conditions of your community supervision. You violated those. But what I'm sentencing you for is the underlying case of abandoning, endangering a child with criminal negligence. Court hereby sentences you to 6 months confinement in the state jail division of TDC. The court will order you to pay the balance of your financial obligations. The court will award you 62 days credit or any other credit that you have in this case towards your sentence for the time that you have spent in jail on this cause. We'll be adjourned in this matter, and state asks you to prepare a judgment, provide a copy to Mr. Knoll. All right, thank you. All right, Ms. Parker, you can step to the back.
Because as far as regulation, still need to review paperwork with this candidate, so I am prepared to go ahead and move forward on this topic.
Okay, yes. Mr. Woodwhite, did you want to approach?
No, I was just confirming Mr. Hall about Phillips.
Okay,
We're ready.
we're ready. Ms. Harper?
Curtis Harper, we need to confirm exactly what the correct name is at this.
Ms. Harper, if you'll come forward, please.
Because I have it as well.
All right, this is cause number CR 1513, State versus Kayla Curtis. Miss Curtis, is your name Curtis or Harper? And is Harper a married name or a maiden name? And where does the name Curtis come from?
And it used to be a boyfriend that I used to date at one point, but I don't know why they have it as Curtis.
Well, look, I see in your indictment back in 2015 that you told the court that Kayla Curtis was your true and correct name. Was that your name back then?
No, it's always been Harper.
Well, all of your judgments and everything in the last 6 years have always said Curtis.
The state's amended motion to revoke does say Curtis, and then the order relating to indigency says Harper.
Well, we're going to proceed under Curtis, and then we can do also known as Harper, because I believe her indictment and let's see, I believe the judgment.
The judge also said Curtis.
Yes.
I will say though, that looking back on the written plea admonishments in April of 2015, they were prepared as Kayla Curtis, but she signed Kayla Harper. So we're going to proceed under Kayla Curtis. Okay. All right, and we're here on a motion to revoke. Is that correct?
Yes, Judge, it's the state's understanding that this Curtis is going to plead true to the state's motion to adjudicate, state's motion to revoke on the stipulation that state abandons count 8 and 9. So she will be pleading true to 1, 2, 3, 4, 5, 6, and 7. On the thing plead true to those counts, state will abandon counts 8 and 9. In the state's amended motions.
Okay. So Miss, and I know you're saying it's Harper, but legally under the documents, it's Curtis. So court, Ms. Curtis, you appeared before the court on August 22nd, 2017. You were convicted of the state jail felony offense of theft of property, $1,500 to $20,000. Court heard the evidence, found that there was enough evidence to convict you. The court did convict you and sentenced you to 2 years confinement in the state jail division of TDC. And then the court suspended that sentence and placed you on community supervision or probation for a period of 4 years. And it's been during this period that the state has filed a motion to revoke and also an amended motion to revoke. The amended motion to revoke was filed August 24th, 2021. And in that motion, the state has alleged 9 counts. And it's my understanding that you are going to plead true to counts 1 through 7. Is that correct? And Mr. Knoll, does your client waive the formal reading of the state's motion at this time? Has she been presented with the motion and has she read over all counts?
Yes, we've gone over, I'm confused now for Harper, Curtis.
Curtis. The indictment is Curtis. The arraignment was Curtis. The judgment was Curtis. Everything was prepared Curtis. She signed Harper. So I think legally under the criminal records, it's probably already been reported to DPS as Curtis.
Yes, we have reviewed it. Certainly don't object to the state of abandoning counts 8.
Okay. So Ms. Curtis, you're represented by your attorney, Mr. Curtnell. Are you pleased with his representation of you? Do you feel like you've had enough time to go over the motion and the amended motion with Mr. Knoll and ask all your legal questions and get answers to those?
Yes.
Feel like you understand everything that's happened in your case so far?
Yes.
All right. And so at this time, I'm going to ask you, Ms. Curtis, how do you plead to counts 1, 2, 3, 4, 5, 6, and 7? Are those counts true or not true?
Sure.
And Ms. Curtis, has anybody threatened, forced, or pressured you to plead true to any of those counts today?
Yes.
All right, court will accept the defendant's plea of true. Court will note for the record again that the state has abandoned counts 8 and 9 in the state's motion. Mr. Woodwike, are you ready to put on any evidence?
Judge, state would ask that you take judicial notice of the court's file, specifically the 2 judgments, the judgment placing Ms. Curtis on
deferred adjudication, community supervision, and then the later judgments adjudicating and placing her on straight probation for 2 years, probated for a period of 4 years.
Any objection, Mr. Knoll?
No, Your Honor.
All right, court will take judicial notice of all previous judgments of conviction or judgment deferring guilt in cause number CR 1513. Mr. Knoll, check to put on any evidence for the defense.
With Your Honor, we call Rebecca Ann Harper.
Ms. Harper, if you'll come forward. Come on up here, Ms. Harper. If you'll raise your right hand. Ms. Harper, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
Please have a seat. You move that chair around. And just try to get as close as you can to the microphone. Speak up loudly and clearly and do your best not to speak over the attorneys. And I ask the attorneys to extend that same courtesy to Ms. Harper. Go ahead, Mr. Knoll. And Mr. Knoll, if you want to move that microphone, yeah, that's a better one. If you want to use that.
Ms. Harper, would you please state your full name? Rebecca Ann Harper. Where do you currently reside?
West Point, Texas.
You know the individual seated to my right.
Yes, she's my daughter.
Going back to when she was first placed on probation on this case, at least 2 years, 2 years probated before, back in August of 2017. Would be a fair statement that your daughter was homeless at that time?
Yes.
There are multiple allegations involving several different kinds of things, some of them similar, some of them not. One of the questions that I asked your daughter, and I don't remember why, it just came to me that I need to ask that question. She indicated to me that what I would call special ed, was your daughter special ed or
Yes.
special education, special classes in school?
Yes.
Do you remember, how old is she now?
27.
And was, I don't really know when you start special education classes, but had she always been special ed?
Yes.
Did she finish with a high school diploma?
Yes.
I'm gonna go back, I know you don't necessarily know the contents of the motion. States motion to revoke the probation. John Radford, so what?
You may.
I just want you to know that there are multiple months involved, and the best way to do that is simply show you that, for instance, on the allegation involving not reporting the probation office block over, so there are multiple paragraphs involving months over actually several years. Court costs, there are also multiple months. Several months involving other payment supervision fees. Restitution being the amount. Okay, well, I just wanted you to know, I understand you get the picture. And then same thing with community service. There's many, we're not talking about 2 or 3 times, we're literally talking about periods. And there's some of the allegations of 2 years or more where things didn't happen. Okay. After doing this 37 years, I'm not an optimist, I'm not a pessimist, I'm a realist. Okay? And that's one thing I think we need to be with anybody that you represent. In this case, that's your daughter. Okay? the problems, one of the issues involved her inability, basically, for the year 2018 and 2019. And most, if not all, actually all, 2020, and half of this year, not reporting to the Van Zandt County Community Supervision Office. During the period of time of 2018, now, I'm going to try to simplify my question. 2019 and 2020, did your daughter have her own transportation? In other words, automobile, she owned an automobile?
I don't believe so. She was with her boyfriend. I don't know if she had a car of her own or not.
Has she ever actually owned her own vehicle?
No.
The last time that you knew she was employed, where was she employed?
It was a fast food restaurant, I believe, in Longview.
And
Not Longview, close to town.
say a fast food restaurant,
I don't remember which one.
okay. And that's fine, was she working as a, you know what her job was there?
I'm assuming just taking orders.
Okay. In the last. Let me ask the question this way, what's the best job that you know of? And I guess the best job, we'll define best job as the one that paid the most. What's the best job that you are aware of that Kayla ever had?
She's worked at Chicken Express, but never anywhere very long.
When you say not anywhere very long, are you talking about periods of just weeks or a few months or?
She may work there for a few weeks, maybe 2 or 3 months. And she's not working for a long time.
Okay. Do you have any knowledge as to why she apparently has difficulty holding the job?
No.
One of the other allegations that involves, again, money issues. Basically the same months, these money issues involve the payment of supervision fees. Was there a period of time when she took care of a family member that was ill?
Not in our family. Her boyfriend's grandfather, I believe, is ill. And then his dad recently.
And I understand that. Familiar with a Pincer, David Pincer, was that the individual?
I'm not sure of his name, so.
Was it a boyfriend's grandfather who was there?
Yes.
There are other allegations again involving payments. Basically the same months. I'm going to move on to a new allegation involving community what's called community service. Me, I think for most judges, it's one of the basic things. Besides reporting is doing community service. The community service allegations are about the same. Now, you've indicated that she's never actually owned a car, 27 years old. Usually when you do community service, you have to get somewhere. Let me ask you this. Let's say since she was placed on probation, and you indicated that she was placed on probation, she was homeless, so she was not living with you. Whatever. Be fair statement.
Right.
And I'm in no way trying to make a comment on why she was or wasn't. I just want people to know that when she walked out of Van Zandt County Jail, she did not have a home. Do you know the first place where she established a residence?
After that,
When she was released from Van Zandt County Jail?
I don't know where she was until she came home with me.
Okay. When did she come home to you?
Well, when she came out of there, yes, she came home with me. No, when she got into trouble, she was not with me. But when she was released from jail, then she came home with me.
And when, then
I'm sorry, I got.
that's okay, well, I think I'm confused now. So, when she was in jail, went to jail, she was homeless at that time?
Right.
Okay, and then when she was released from Van Zandt County Jail, and actually twice, because apparently she was on the third at one point, got out on one kind of probation. That kind of probation was then moved to another form of probation, regular probation versus deferred. So it would technically probably be maybe the second time, or maybe maybe she wasn't even taken into custody, but when she eventually got out of the Van Zandt County Jail, did she move in with you?
Yes.
Okay. Now, how long did she stay with you?
I'm not sure, so.
Would it have been weeks, months?
I believe she was there for a few months.
And if you recall, during the months that she was there with you, did she work?
For a little while, yes, I was taking her back and forth to work.
Remember where that was?
She worked at a McDonald's.
And where were you living at the time?
Most of it.
Rose Point? And was that McDonald's the one at the street?
And yes, at one point she was working at the McDonald's here, I believe.
And you said that her only transportation in was you taking her back.
Yes,
Are you a homemaker or
I work.
you also work? Did she ever? Well, so that I don't make a mistake about asking you that question. Community service is when you are, in essence, paying back the community for the wrong that you've done. You're gonna go someplace and do something to help the community. I think as Brian indicated earlier, that one of the things would be help maintain the park, for instance. As far as community service, you recall, if Kayla ever asked you, can you take me wherever to do community service?
I remember a couple of times taking her to, I think I was very camp one time. And I think, well, might be the only time, so.
Okay. In reviewing, again, the allegations, I'm going to read paragraph 7 to you. The defendant violated condition 5 of her supervision in that she failed to complete a cognitive behavioral training course within 90 days. You know what that means?
Were the accessories supposed to take us to the?
No, and again, I'm not, the reason I'm asking it is I'm not sure exactly what that means, but I probably do. So in other words, let me ask the question this way. If she always attended special ed classes, it's also my understanding, maybe they do, maybe they don't, and she always go to school in Wills Point or
Always a little.
Wills Point may have exercised their right to destroy all records after 7 years. In other words, once she was 25, they can get rid of all records. Did you ever attend the art meetings
Every year.
every year? Okay. My second ex-wife was a special ed teacher, so I know a little bit about that. Okay. So if we talk about, and I know you did attend today, your perception over the years, 27 of them now, really what level, age-wise, she is 27 years old, but age-wise, what level does she operate at? Based on your experience, not only as her mother, but in attending the multiple art meetings that I'm sure you attend.
Definitely about 27.
You have a guess.
I would say 15 or 16.
So close to half of her age. In other words, a mid-teenage.
Yes.
You may.
Let me ask you that. That she's on probation for, do you know what was stolen? What's been stolen in the original test?
No, sir. I don't.
Okay, then. Further questions?
Mr. Woodwhite?
Just, ma'am, are you aware that your daughter owes between probation fees, restitution, and other costs, almost $11,500? Are you aware that she is behind $8,625 in restitution? Are you aware that since you placed on deferred adjudicated probation in 2017, which if my math is correct, that's 48 months ago, 48 opportunities to report, she reported 8 times?
No, sir. It's not.
Ma'am, are you aware that she was ordered to attend sanctions court, which is court in this courtroom twice in October and November 2018? I believe you told Mr. Knoll that of those 48 months that she was supposed to report, she has reported, by my count, 1 month of community service restitution. That's community service.
a one term over here. I don't know.
I believe you said that she worked in the last, the one that you were aware of, she worked at a fast food restaurant in or around time, is that correct?
Yes,
How did she get?
that I'm not sure, so she wasn't.
Okay.
I think she was showing her boyfriend's car.
Mr. Noel, any additional questions from Ms. Harper?
I hope this is very more that. Also, you're understanding now, if you've seen the child with the daughter, as a child of her own,
Yes, I know she does have a child.
what have you? I'm sorry, I missed.
My grandbaby, yes, sir, I know she does. How old is that child? She's almost 8 months.
And where's that child now?
She's with CPS.
I don't have any further questions.
Any further from the state? All right, Ms. Harper, you may step down. Thank you. You may.
That way, that's all we have. Sorry.
All right. State, do you want argument
Very good.
or rebuttal if you have any rebuttal evidence?
Staff never rebuttal.
All right. Go ahead and take argument at this time.
Judge, this case is fairly clear. Ms. Curtis was placed on probation August 21st, 2017. She failed to appear in October of 2017. Basically, has done nothing since. It appears she did 1 month on probation. She's been sanctioned. She's already been on deferred adjudication. We afforded her every opportunity. I understand it sounds like she has had a rough go of life. The state is not unsympathetic to that, but she was aware what was required of her when she signed this paperwork. She was aware of what she was required to do when she was ordered to pay restitution, when she was ordered to report, she was ordered to take drug tests, she was ordered to do all of these things, and she did nothing. Judge, we would ask you to enforce the sentences previously been sentenced to her.
Thank you, Mr. Woodward. Mr. Knoll.
Not an optimist, not a pessimist, a realist. And I represented this Curtis. I would have done my best, to try to get her just to move time, that I know, maybe lawyer didn't at the time, about the totality of the circumstances. Cognitive behavioral training course. In this case, for Ms. Curtis, the concept of probation may have been a cognitive training course for her, in that she needs to pay attention, a lot more attention to what life throws at her. Quite honestly, I think based on the testimony of her mother, there's a lot of things that life will throw at her that are going to be very difficult for her. Probation has been one of those for many reasons. It's amazing to me, made still of a lot of things, that someone has difficulty holding down a job. I've never drawn an employment. I've managed somehow to continue to do this for 37 years. But I understand there are people that have limitations. I only have one eye. That's my limitation. You can see. The limitations Ms. Curtis has, you don't see. So if you don't ask the right questions, if you don't do everything to find out what is the client back, then sometimes you make the wrong decisions, sometimes you make the wrong recommendations, sometimes the client makes the wrong decision. Fortunately, and many of those. Certainly the court can impose 2 years. Honestly, I don't know that 2-year imposition for Ms. Curtis is gonna help her a whole. Maybe the cognitive training course would, and I'm certainly not asking because I told her, be that realist. This is not back on probation. She got very angry with me when she said, why don't I give another chance? What I said to her was, well, for instance, in February 2018, when you did the report, you had the opportunity to report in March, or May, or July, or August, or September. She got very angry. I literally don't think she understood that these were chances to be right. For many reasons, she didn't. Whether it's transportation, inability to hold a job, it would appear to me that she has had limited resources. As her mother indicated, she never really had a good job. When she's had one, she never had them all. And I do understand it's a little upsetting to the court that somebody basically did nothing for 2 years. Thank, because I went over each and every month, we did, each and every month. There are a couple of paragraphs, maybe more than a couple, where she did nothing she was supposed to do for periods of 2 years. Is sentencing her to 2 years and fix that? It will literally be punishment for punishment's sake. Sometimes I think that's appropriate. In this case, because we're here on her case, not every man's case, I don't think that's appropriate. Should it be 6 months? I'd be as candid with this court as I can be, just like I am with my client. I don't think it should be 6 months. I think the court made an appropriate decision in my opinion on the other case. I honestly believe it should be less than a year, even though she did nothing for 2. So, they didn't need to.
Thank you, Mr. Knoll. Anything further from the state?
Judge, I would just say that the period of 4 years would seem, that's, I believe, just this day, that's fine. No, stay as that.
I do find that Ms. Curtis would have to show up for the probation department to know what her abilities are or what they aren't. So that's something that I do take away from the argument. It's a good argument, but Ms. Harper Curtis, court is going to find, based on your pleas of true and the evidence today, that you have violated the terms and conditions of your community supervision. The court finds counts 1, 2, 3, 4, 5, 6, and 7 to be true. Court is going to revoke your community supervision, and the court assesses your punishment at 15 months confinement in the state jail division of TDC and orders you to pay the balance of your financial obligations. And the court awards you any credit towards that sentence that you spent in jail at this time. State, I direct you to prepare a judgment, provide that to Mr. Knoll. And we'll be adjourned in this hearing. Go ahead. And Miss Harper, you can go to the back. We're going to stand in recess for 10 minutes. Give you a break. I'm not worried about it. Just leave it there. All right, this is cause number CR 29-1, State versus Amanda Templeton. Ms. Templeton, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Ms. Templeton, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? What have you been diagnosed with? Okay, are you currently on medication for any of those? Are you undergoing treatment for those? Do you feel like the fact that you're not undergoing treatment or on medication is making it difficult for you to understand the proceedings? Feel like you have a clear head today and you understand what's going on? In this case, you're represented by your attorney, Mr. Kurt Knoll. Are you pleased with his representation of you? Feel like you've had enough time to discuss your case with him and have all your questions answered? Anything about this paperwork that you've read and signed that you do not understand? Mr. Knoll, do you believe Ms. Templeton to be competent today? And you've explained to her her legal and constitutional rights? And do you believe that she understands them? All right, Ms. Templeton, I see here that you're charged by indictment with a state jail felony offense of abandoning or endangering a child with criminal negligence. That is, that a state jail felony does carry a range of punishment of not less than 6 months or more than 2 years confinement in a state jail facility of TDC and a fine not to exceed $10,000. The proposed plea agreement appears to be that you're going to plead guilty to that charge in exchange for the state's recommendation that your punishment be assessed at 8 months confinement in the state jail division of TDC with a $2,000 fine, $290 court cost, $90 reimbursement fees, and that you would receive 53 days credit towards your sentence for the time that you've spent in jail on this cause. Is that your understanding of the plea agreement? And that's what you want the court to approve? Then, Ms. Templeton, let me ask you, how do you plead to abandoning or endangering a child with criminal negligence? Are you pleading guilty because you are guilty of committing that crime? Has anyone threatened, forced, or pressured you to plead guilty? Court accepts the defendant's plea of guilt. Mr. Nolan, the objection to states one. States one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state? Anything further from the defense, Mr. Nolan? All right, the court will find that there's sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement. Court convicts Amanda Templeton for abandoning or endangering a child with criminal negligence, assesses her punishment at 8 months confinement in the state jail division of TDC, orders her to pay a $2,000 fine, $290 court cost, $90 reimbursement fees. Court awards her 53 days credit towards her sentence for the time that she has spent in jail on this cause. Ms. Templeton, is your child in CPS care at this time? You lost your rights? Did you give up your rights or were you terminated in a hearing? Terminated. Do you know if your child's with family or with foster? Do you have any other kids? Do you plan to have more kids in your life? Plan on doing things differently? I'd hate to see you get out of prison and go right back to doing methamphetamine. You really got probably a small window of time to get that fixed in your life. You understand? How old are you? 22. I'm an old man, so I can say you're very young. You got a lot of life left ahead of you. And that life can be positive, it can be good, it can be productive, it can be great. And you can look up in 20 or 30 years and this be a faint memory, or it could be the start of something that's a terrible life, where you live your whole life in and out of prison. No, I hope so. I don't want that. I'm sure your family doesn't want that. So while you're doing your time, be thinking about positive things that you can focus on when you get out. You understand? All right. Hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step up here with my bailiff to be fingerprinted. All right, I believe that concludes this afternoon's docket. Court will stand in recess till tomorrow.